Good evening, Deepak. Revati, good evening. Soy, welcome, Kanna. Varun,
Hi, Deepak.
welcome.
Good evening.
Yeah. Sai Teja, welcome. Jasmine, welcome. Deepak, always first person. Welcome, Kanna. Parvati, good evening. Yeah. Aditya, welcome. So, very good evening to all of you. Welcome to Premier Academy's webinar series for CA students. You know, in MCQ, selecting the option is little difficult. Same manner, choosing the faculty also for me very difficult. Getting appointment from the faculty. Sorry for the delay with respect to connectivity issue. So thank you for your passion waiting also. We'll start our program. How to approach CA, IPCC as well as intermediate law MCQ. How to approach MCQ based on MTP, right, sir?
Yes, sir.
Current MTP. Sir is going to explain, Bharath Kumar sir is going to explain how to attack MCQ point. Welcome, Bharath Kumar sir.
Thank you, sir. Thank you so much, sir. So happy evening, guys. This session, as we have already told in the previous session, we will take a separate half-an-hour session for MCQ of RTP and MTP. The most important coverage to decide what is your first group's base is after you complete your accounting to start with your law paper. So when you see law, there is going to be differences relating to MCQ, case-based question, and your direct question and answer, as I've already told in the previous video. In MCQ, again, there will be two heads. One is going to be case-based MCQ, another is going to be direct question and answer. So whenever you cover your 30 marks, the 30 marks will belong to not just 1 mark, it can also be 2 marks. So we need to be really strong on knowing what type of questions that they can ask in the examination, how you wanted to track in. We always say in psychology, eat the frog first. That means when you know what is to be done for MCQ, that's on one side, but how to cover your practical questions. So first, if you cover your practical based questions or the case based question, there is a methodology in which you will have to try to do it. So we will go one after another, and I will also tell you how to cover up your basics of your MCQ. Let me take for an example. Let's take for company law. For your old syllabus, there will be 7 chapters. For your new syllabus, there will be 10 chapters. The first flow for you to remember your MCQ is what type of chapter, which chapter it is going to be from. Let's take for an example, company law. Chapter number 1, your definitions. Chapter number 2, incorporation of company. Chapter number 3, prospectus and allotment of securities. Number 4, share capital and debentures. Number 5, deposits. Number 6, charges. Number 7, management and administration. Number 8, dividend. Accounts of companies is 9. 10 is audit and auditors. When you start with a case-based question on RTP or MTP, the first thing is what type of company it is, whether it is a small company or a private company or one-person company or public company or limited by shares or limited by guarantee, because based on that only you will try to manage what type of question it is. The second most important thing is the parties that are available. Who are the people available? When you read the case-based question itself, you will try to understand that, okay, this is from Indian Contract Act 1872. This is from Negotiable Instruments Act 1881. This is from company law. when they cover the case-based question, easily 4 chapters they will cover. Let's take for an example, incorporation of the company. There will be something related to MOA, AOA on a particular one, or it can be related to Section 8 company alone, or it can be related to one-person company. In that, there was an annual general meeting held. So the members reside or apart from the registered office. That's the second chapter, management and administration. Then the third, they will say books of accounts they did not maintain properly, how long they will have to maintain. So connecting your accounts of companies. Then our auditor appointment is already there. What type of appointment, how you will have to cover. So this, if you again try to see, you will try to have 4 ways. So what is that 4 ways? Number 1 is incorporation of company. The second is management administration, accounts of companies, audit and auditors. So like that, you can manage your case based in a different format and in your different chapters. There can be a positive question, there can be a negative question, or there can be a non-negative question. We need to be very careful. If you have heard Vikas sir's MCQ related questions on your auditing, again you would have understood that. Okay, so that will be a non-negative based question also. That means indirectly, which is not forming part of it. So which is forming part of it is positive, which is not forming part of it is negative. So like that type of questions you can accordingly cover, and we can know this. Okay, now we'll go inside the MTP and we will try to see what are the things that we need to cover. Okay, so yes, now let's go inside this. I'll make it bigger. Now we can accordingly see what are the MTP questions that we have. See, listen carefully. What I have done is I have brought in for both old syllabus and new syllabus. I'll also underline the keywords. So let's see how far you are able to remember. Now, see the question here. I will quickly underline also when we wanted to. Now, the question is based on a person called Abhinav Gyan. Okay. He is a tech expert. Okay. He pursued masters in management. He did artificial intelligence. All that is fine. And then he wanted to go and retain the profit of the company. He wanted to see, but the shareholders are seeking the dividend. Okay. So the first one is dividend chapters they are trying to connect. Okay. Now, the outbreak of COVID-19 is another reason after the closure of books of accounts. So when I say books of accounts, automatically I'll go to accounts of companies. The director proposed the dividend of 10% against the expectation of 20%. So there is a difference between the 10% and the expected 20%. See the next point. By considering the extended lockdown, the directors are opinion to revoke the dividend because they don't have a easy way to provide. Okay. Next, shareholder seeks the appointment of internal auditor. Automatically, you will try to go back again to accounts of companies on internal auditor section 138. Whereas the management says it does not require to appoint an internal auditor under the law and it will be a financial burden. They have told paid up share capital, turnover, outstanding loans, outstanding deposits, intercorporate loans. They have also brought in 25 crores till January. It is 30 crores. Now what they have told, this is only one part of it. This is only one part. Now see the next level. Already what and all we have told. We told the person is seeking for dividend. Second is internal auditor, and that means you are connecting your accounts of company. See the next one. Out of the savings bought 40,000 shares of another company. On such shares, the final call is due. 2 is due but unpaid. So whenever you try to do unpaid, the dividend and unpaid call will be set off. So again, that is the most important thing to be remembered. TCS declared dividend at the rate of 15% only. Where TCS is coming, see the point. Gyan, one of the shareholder of DTL. So 3 people are involved now. Mr. Gyan is involved, shareholder of the company called DTL, and he bought the shares of another company called TCS. So 3 are getting involved. So TCS declared a dividend at the rate of 15% because they are also having a perspective on that. So there are various amounts that they are declaring at each particular point of time. That is again one part of it. See the next one. Mr. Gyan wants to form part of your ethical commitment and he decided to form a Section 8 company. Now where are we going? We are going to incorporation of the company. Section 8 company. Section 8 company around 2 years back, who became later the member of the company. receipts or excess of expenditure, it was decided that Gyan Foundation will declare some dividend to members. Okay, this is one part of it. Now, if you see this whole case law, if you read this case law again and again 2-3 times, you will understand Gyan is a person involved. Then DTL he is the shareholder in DTL, and they bought the shares of another company called TCS. So 3 people involved. Now dividend declaration is happening, internal auditor appointment, then section 8 company, then they wanted to cover whether the declaration of dividend is allowed or not. So all these things, if you cover, you will get a better perspective. See the next one. See the question now regarding the unpaid call money of Mr. Gyan in the light of dividend due to him from TCS, state whether the following statements hold truth. Now, what did I say? I told dividend, whatever is unpaid will be adjusted against the unpaid call money with the dividend. So, A, dividend can't be readjusted. It can be readjusted. How it can be readjusted? See the 3 points. A dividend of rupees 48,000. That means your 4 lakhs divided by into 2 by 100. So 48,000 you will have it adjusted unpaid call money. The third is dividend can be adjusted at unpaid call money if consent is given. No consent and all is required. You can declare dividend and definitely you can adjust against it. Is what is our base. The third is the dividend of 64,000. The calculation itself is wrong. So it will only be 48,000 because only 2 per share is unpaid. So automatically you will try to go for option number 2. This is one part. See the next one. Does the TCL require to appoint internal auditor under section 138? Yes, because the turnover is more than 200 crores. So automatically you will go to section 138. What is the next one? With reference to dividend of declaration, which of the statements hold truth? Gyan Foundation can declare dividend out of capital. That is one side. Second, declare dividend need not transfer percentage to reserve. That is only discretionary. It is not mandatory. The third, Gyan Foundation can't declare the dividend because 3 years has not elapsed. That also is not the point. What's the major? Gyan Foundation cannot declare the dividend in any case because it has gone to the section 8 company. So when you cover section 8 company, automatically you cannot declare dividend. This again will be connected with your section 8 companies. Next, what is the penalty? So against that, if you calculate, the penalty will be INR 108,000. So this is under section 127, which we have already told you. The limit will be based on that. So we are done with the case law question. What is this? They are talking about 2-3 cases they wanted to cover. See the next one, Mr. Mohit Agarwal case. Okay, so what is he? He is a director. Okay. Second, he acts as a public company. He accepts loan from Mr. Rohit of rupees 1.5 crores. So the second people is going to be SECL. SECL is the company, and company accepts a loan from Mr. Rohit. The moment when you say loan, you will try to go and get connected with a chapter called deposit, because the word deposit will also include the word definition of loan. So that also has to be considered. But whether they are accepting it fully or not, you should cover. See that next point. SECL in its books of accounts and records under non-current liabilities at the time of advancing loan, Mr. Mohit affirms in writing that amount is not being given out of funds acquired by him for acceptance of deposits. That means he has accepted loan only, but he is not taking it from the funds, or he is not providing it by way of deposit. So that means it will not be considered as a deposit. The third one, SECL has a registered office in a particular place and corporate office in another place. The moment when you try to come back, you will try to go back to management and administration. What are they? Registered office in one place and corporate office in another place. Can you fix the meeting, or can you fix the annual general meeting, or can you keep the register of members in any other place apart from the registered office? Because only when you have 2 reasons, you will always have a comparison. See the point here. But around 15% of the members are whose name is entered in the members register. The beauty is what? The beauty is even when it is more than 10%, with the special resolution, you can try to move from one place to another place, even when they are not of the registered office. So at Nainital, SECL has a liaison office. Can you try to do it? So that again it is possible, because more than 10%, if you pass special resolution, it is going to be there. This we would have already studied when we studied our basics. The next, SECL convened its 7th AGM on 10th September at the registered office. The notice was served on 21st August. Okay, so you will have to check the clear days, 21 clear days. So apart from the day on which you are sending, apart from the date on the meeting, there should be 21 days. More than 78% of the members gave consent. Now, the beauty is, between 7 and 20 or 21 to 10th September, you will have to check whether it is more than 21 days or less than 21 days. If it is less than 21 days, you need to have 95% of the members giving consent, but it is only 78% here. So let's check the MCQs also. Now, what is that they are saying? 78% of the members gave consent to convene AGM at a shorter notice because of another lockdown starting from 11th September. You know, based on this pandemic situation, you will always have a difference of how much of notice has to be sent. Notice 21 clear days, yes, but if it can be less than 21 days, it is still possible, but 95% has to be provided. Only then you can try to have a lesser or shorter notice. See the next point. When you cover this second wave, on the basis of above facts, answer the following MCQs. What are the MCQs that we need to cover? See the first point. With reference to the loan advanced by Mr. Mohit, apprise whether the same is classified as deposit or not. It is not a deposit, as I've already told you, because the return declaration is provided by Mr. Rohit that the sum of loan is not being given out of the funds acquired by him for borrowing or accepting loans or deposits from others. He has openly told it is not going to be a deposit, because he has given a written declaration that this loan will not be considered as a deposit. So the answer is very simple. When you read that MCQ itself, you will know that there is a small tweak. So only they wanted to give this as an option. See the next point. The register of members, where they can keep it. So they can keep it any other place or not? Yes, as per the provisions of the Companies Act, Management Administration, they can keep in any other place. But what is the most important thing? The register of the members can be kept at any other place, but 1/10 of the members should be residing in that place and passing a special resolution. So the first point, the register of members shall be kept either at registered office or within the same city. After passing the resolution, SECL can't take place. No. What resolution? Special resolution. It can take place in any other office of business. Ordinary resolution is the second point. No, that's again not the answer. What is the resolution? I told you, special resolution has to be passed. So after passing a special resolution, 1/10 of the members should be entered in that particular place, residing there. So that's the keyword you will have to remember. The third one, considering the provision dealt with the length of notice, I already told you 21 days clear notice has to be given. But if it is a lesser notice, at least 95% of the people should vote. So here they said shorter length need not be consented. That's wrong. Second, consented by 75 members, again not right. Consented at least by 50% of the members, not right. The answer is 95% of the members has to be provided, and only then the notice that will be served will be valid. This is going to be the case-based question. Now let's see what we have actually done for it. See the point here. Now the first thing, the coverage of the case-based MCQ. What I have done, I have covered the MTP question on November 20, mock test paper. What is the first thing rule that I wanted to say? Read the case at least 2 or 3 times. When you read the case, you will understand the flow of the case. Who is that person? Whether he is going to be a one-person company or public company or private company, or whether he is a shareholder in a particular company. Second, identify the chapter number and names. I already told you the chapter flow. See the point here. I have clearly made corporate and other laws when it is there. What type of case? What are the chapters it is there? In which particular way they will try to manage that? Whether it is management administration and dividend and accounts of companies. So you can accordingly remember it in the way. The third one, type of company, whether it is one person company or small company or section 8 company accordingly. Next, identify the persons and eligibility of the persons involved. He can be a minor, whether he will be capable of contracting. If there is an appointment of auditor, whether it can be internal auditor or external auditor, and who are all the contracts entered into by the parties. The next one is identify the positions handled, whether he is a member or director, because according to that situation also it will be manageable. Next, list down and mark down the events occurred, whether the conversion of company is happening, whether dividend declaration is happening, whether contractual terms is happening, what type of event it is, whether it is a positive or a negative event. So only when you know whether it is positive or negative, you will know whether it is to be applicable or not applicable. If there is a negative, means what is the exception. Next, what is the limit? I told you like 95%, 75%, 50%. So see the limits. Whether it is internal auditor, means you should know the limits under section 138. When it is CSR committee, you will have to know the limits under section 135. So like that, you should try to manage it. So these are the coverage of the case-based MCQs. If you try to remember this in the case, it will become very easy. See the next one that I wanted to cover after this. Now I have covered the MTP MCQ. Now see, after that there are some basic direct questions. I told you in MCQ there can be two type of questions. One is going to be direct type of question, another is going to be case-based question. In case-based question only, you should decide what are the events that you will have to remember. When it is direct question, you don't need to bother. Directly you can go and find out. See the next one. When a copy of contract for the payment of underwriting commission is required to be delivered, how many days? If you see the moment when you see payment of underwriting commission, you will remember section 40 of your Companies Act. So it is at the time of prospectus for registration. It is not 3 days before the delivery. It is not after the delivery. This they will confuse. If you know the full keywords, when they start itself, they will say it is at the time of delivery of prospectus for registration, whether shares are to be considered or debentures are to be considered, and you will have to compare it with AOA. So it is not before or after, it is at the time of delivery of prospectus. So that's the keyword. This and all is direct question. You will be able to get the answer really strong. Next, Prithvi Limited is issuing debentures carrying voting right. The moment when you see voting rights, don't jump to the conclusion, because here they cannot issue debentures with the voting rights. So you will have to know what is the basics of the provision. Next, statutory auditor. What and all he should try to see in when he wants to report it. The first one, the employee is appointed during the period, whether his educational qualification is perfect. He is not bothered about what is that educational qualification. Second, whether the signature of the chairman or not in the minutes, chairman only has to check and properly give. It is not about the statutory auditor, it is there. So this is a financial matter. Next, what are the incorporated documents, whether it is managed properly. So it is only finding out the true and fair view opinion, and automatically this will not be a financial matter. So which of these is a non-financial matter? So the keyword is whether he is allowed to be qualified or not qualified. Here they will have to check whether any director is disqualified under section 164(2). Though it is covering your CA final syllabus, you will have to know whether he is qualified or disqualified, because they are bothered here in this particular question. They are asking what is the non-financial matters and not about the financial matters. When it comes to your audit and payroll department, will take care of the first point. Second, chairman itself will take care, and company secretary will liaise with him on the minutes of the book. Third, incorporation of the documents managed properly. You don't need to wait for statutory auditor. Even internal auditor would have done. All this will be based on your financial matters. The last one only is your non-financial matter. Next, if the company changes its name, which of the following is most accurate? It is not allowed to use old name in any way. No, you cannot say old name you should not use, but you will have to at least tell the old name of the company and then the new name, so that people will not have a problem. New name should not be identical with the old name. That is not going to be the criteria for Companies Act. See the C and D, that only will be confusing. The old name should be painted or printed for next 1 year or for the next 2 years. The Companies Act makes it very clear. At least for 2 years, you will have to have a painted or printed. Old name should be there, new name should be there, your old number, new number, registered office, everything has to be clear for 2 years is what they have told in the Companies Act. Next, very simply, they will ask you questions on Indian contract, whether what type of contracts it is going to be. Indemnity versus guarantee, bailment versus pledge, agency, sub-agent versus substituted agent, holder versus holder in due course, sans recourse versus sans phrase endorsement. Like this type of meanings and confusing questions they'll ask you. I'll again repeat what they will ask you in your Indian contract and negotiable. First, they will ask you indemnity versus guarantee. In guarantee, whether it is specific guarantee or continuing guarantee, they will ask. Bailment versus pledge, where the responsibility of bailer will come, where the responsibility of bailee will come, where the response of pawnee will come, where the responsibility of pawnee will come. So that rights and duties, when you cover, you will know. Principal versus agency. Agency, when agent, when he can act in emergency, when he should do as per the principal's direction. Again, this type of confusing question will come. Next, what is sub-agent's role, what is substituted agent's role. Like this, they will try to compare. You will have to check whether it is 2 people or 3 people. When it is going to be 2 people, indemnity. When the principal debtor is going to be protected by the surety against the creditor, then it becomes guarantee. See the point here. Whenever, if that fellow is not able to pay, but this fellow has promised to pay in his default, then automatically guarantee will come into picture. See the next point. Where A obtains housing loan from LIC Housing, and if B promises to pay LIC Housing in the event of A failing to repay, that means automatically he is giving as a surety, saying that if you fail to repay, then I will pay you contract of guarantee. See the next point, I already told you. When it covers to bailment and pledge, who is responsible? Like that type of question they will ask you. A hires a carriage of B. The carriage is unsafe, though B is not aware of it, and A is injured. Okay, A hires a carriage of B. B do not know that it will going to be injured, but somehow A got injured. B cannot escape his liability and say, sorry, I do not know that the carriage is unsafe. Definitely B is responsible to A for the injury. So you should definitely know whether he is knowing it or not. Caveat emptor, let the buyer beware. That's okay, that's perfect. But whenever you know it is going to be a default or not, however that person is affected, the aggrieved party is always responsible to claim that from the other person. That's again very important. The next one is going to be based on interpretation of statutes. If you see in the new syllabus, there are 6 constructions that are there. Literal construction, beneficial construction, harmonious construction, mischief rule, exceptional construction, and then your ejusdem generis of the same kind of species. Here, whenever you use about the word, in our class we would have told very clearly 5 points for each construction. I would have told what is going to be for what meaning, whether it is sensible meaning, ordinary meaning, or confucius, ambiguous meaning, whether it is of the same kind of species, whether you will have to go back to the history and find out what is the purpose of the act. All these things, one keyword I would have told you. Based on that, if you see, dash is the cardinal rule of construction, where the words, sentences, and phrases should be read in ordinary, natural, and grammatical meaning. So the point is, when I would have started literal construction, I would have told it is ordinary, natural, and grammatical meaning. When it comes to sensible meaning, it will go to another construction. It will try to go to beneficial construction. So you should know the difference. Harmonious means when there are 2 provisions and you will have to give effect to both of it, then you wanted to do accordingly. Beneficial construction. So based on your sensible meaning, you will try to do. So like that, the words when you try to use, it will make your job very easy. Next, where an act or omission constitutes an offense under 2 or more enactments, the offender shall be liable to be prosecuted and punished. This is a very generic question from General Clauses Act. Now, you based on the offense, You cannot punish him twice. That's the basic thing. You are also affecting here. There is another provision where he is prosecuted and punished, means 2 times you cannot take that enactment. So that's based on your General Clauses Act. So under either of those or any of those enactments only he can be punished. That's what they are trying to say. The next is most important thing for your case-based question also, but they have asked this in MCQ. X bails his ornaments. That means what? Bailment is happening. Indian Contract Act. X and Y are the 2 parties. X bails his ornaments to Y and specifically instructs Y to keep in the bank. Okay. If that Y has kept that in the bank, then there is no problem for the bailment. But Y keeps the ornaments in the own locker, and after 2 days, all the ornaments are lost or stolen. Who will be responsible? Undoubtedly, Y would be responsible for the loss, because X has already clearly told Y that it should be kept in the locker, in the bank locker, not in his own locker. Okay. So when he is keeping in his own house, then Y only will be responsible for it. As simple as that. So the next one, with regards to the contract of agency, which of the following statement is incorrect? Now, I already told you there is a positive question or there is a negative question. What is incorrect? That means all the options will be right except for one. What you should try to find. See whether it is correct or not. The person who is a major can appoint minor as an agent. Agent being a minor is no problem at all. Correct. Second, if an agent happens to be a person incapable of contracting, the person cannot hold the agent liable. Undoubtedly, yes, because when the agent is minor, it is principal's liability and principal only should take care. Third, no consideration is necessary to create an agency. It is nudum pactum consideration. Consideration, even if it is not there, you should know. Correct? So it is correct. For agency, there is no creation. As per the Indian Contract Act, there is a word called nudum pactum. Consideration is required, only then contract will be there. But there is an exception where there is no consideration also, agency can be created. So the third point is correct. No consideration is necessary to create an agency. So that's also correct. Next is the acceptance of the office by an agent is not a sufficient consideration for the appointment. The point is this: the acceptance of the office by an agent is not a sufficient consideration is incorrect, because whatever is the consideration that you wanted to give, you should have already told before itself between the principal agent relationship. So if you try to see, managing this particular work is going to be very important. Agency and the acceptance will go along with a sufficient consideration. That itself will be taken care when you wanted to do about this. So going back to the concept. Now what we have already told, when we told the corporate and other laws, which is considering your new syllabus, or the law, ethics and communication of the new old syllabus, you will try to know what type of chapters. I'll again quickly sum up what is going to be there. So it's going to make your job easy. Number one, whether it is going to be with the flow of the case, whether you understood or not, whether it is a private company or a public company or a small company. In small company also there is a word. Small company is not a public company. In one case they have told it is a public company. What are the limits of the small company? The answer is already there. In a public limited company, small company will never be considered, because small company is a part of private company and not your public company. So the difference, if you try to understand, it is going to make your job easy. Second one, chapter names. Third, type of the company. Fourth, eligibility, whether he is eligible. Now only we were talking about the minor and auditor and contract entered into, whether it is bailment or pledge. Who is the bailer? Who is the bailee? Who is the agent? Who is the principal? Who is the sub-agent? Who is the substituted agent? Like that, if you try to cover, you should know that that's the difference that we should find. Next, events occurred. What happened? Whether dividend declared, whether dividend is declared at the time, whether it is paid as per the Companies Act 2013 or it is not paid, whether they have transferred the profit to reserves or not. In one question they have told they did not transfer the profit to reserves. What should be happening? The Companies Act clearly says It is not mandatory for you to transfer the profit to reserves. It is only discretionary. So dividend declaration, again, when you wanted to move from Section 8 company and then to private company, whether it is allowed or not allowed, whether the company which is 1% company, can you convert that? Yes. So that type of conversion of companies question they are asking you. Negative points, just now we told what are the negative questions, whether the series of event is positive or negative, and then the limits to be considered. Let's take for an example, when there is a CSR committee, there will be 3 limits, either or condition. If at all you try to manage that, you will know whether it is or condition or and condition. In small company, it is not or condition, it is uncondition. So there is a difference in which you will try to find out. If you manage like this for MCQ, easily you will be able to get 30 marks. So take this from me. Law is going to be in a different way if you start MCQ. MCQ, you can listen to it, but only 40 minutes is allowed for you to complete that MCQ, because 30 marks is going to be sure. It is not going to be 30 questions. It can also be less than that, because there will be 2 marks awarded for each of the question. The most important thing is the flow of the case. Sometimes many people ask me, sir, should we write the facts of the case? Not necessary to write the facts of the case, because it is not going to be of value addition to anything. The most important thing is, should you remember section numbers? Yes, please remember section numbers to the maximum possible extent, so that when you write, it will have a tremendous impact on the examiner's perspective. So the maximum time you are able to quote the section number, it's great. Sir, I'm not able to remember the section number. Can I write chapter number? Yes, please. As I've already told you, whenever it is from deposit, you can say chapter number 5. Because as per the Companies Act, there are totally 29 chapters. In our interlaw, there are 10 chapters. So if you see the 5th chapter, it is always deposit. 7th chapter, management and administration. 10th, audit and auditors. So you can easily refer the chapter, and you don't need to write as per the provisions of the Companies Act. That everybody knows it. The what is the most important thing is to know the chapter number. The next most important thing is, if you are getting stuck with a particular question in MCQ, don't bother about it. Go to the next question. So there is always a time for you to proceed. Keep 40 minutes as an overall basis, but don't spend too much time on a question. Whenever there is going to be case-based question, please read the case at least twice or thrice, as I have already told you. Only then you will know where is the tweak that they have given it from the institute's perspective. Direct question, there is no problem. If you know the meaning, if you know the provisions, if you know the applicability, if you know the non-applicability, automatically you can try to answer. The case-based question, it will be easily 4 or 5 particular chapters would have got covered. So you should know what and all chapter is covered. Preferably, I would say, please write it and keep it and say, number 1, this chapter is covered. Number 2, this provision is covered. Number 3, this chapter, this provision is covered. So like that, like how I have kept it in a way, so you can accordingly know it. So whether it is penalty, or whether it is internal audit, or whether conversion of the company, like that, if you write it, it is going to be easy. I would also suggest you one thing. Whenever you know that it is going to be Indian Contract or Negotiable Instruments Act, you can write it and start saying, as per the Indian Contract Act, and this particular heading is covered. You can try to write like that. Even if you write like that, section numbers at that time may not be required for the examiner, because they will only see, have you understood from where the source is coming? Have you understood whether it is non-applicable provision? Have you understood that there are exemptions to this particular provision? Have you understood whether it is or condition or under condition? Have you understood whether it is ordinary resolution or special resolution or board resolution? Have you understood that central government also can come into picture? Have you understood that these forms you should remember is as per the provisions of the Act? These are the things that the institute will check. Preferably verbatim you can try to write, but however, at least if you write special resolution to be passed, if there is a short notice, at least 95% of the people who are entitled to vote should have been provided. Special resolution and 1/10 of the members residing in that particular place is sufficient for you to cover. When you cover keywords like this, it is going to be very easy. Cooling off period for auditors, 5 years. Individual, it is 5 years. Firm, it is going to be 10 years. Disqualification, as per this particular section, a prohibited services of auditor, internal auditor, 3 limits are there. That's our condition. If you write like this to the point, it is going to be great. One more important point before I wind up. Whenever you write the case-based answers for it, then and there underline, double underline the keywords, and then go to the next question, because you will not have time at the end to see what is the keyword. So underline then and there. Even in the question paper, if you underline that with the pencil, it is going to make your job easy. So like this, if you cover, you can manage your MCQs very well. I've already spoken about on the expected questions or the last minute revisions for law in the previous video. Connect that video and connect this video, you will be able to understand, because there also I would have told some provisions and expected question. In the expected questions which we shared in the PDF, there also we would have told what type of questions can come in MCQ, and we would have covered all that in our recorded classes also. Because now everything cannot be live classes, we would have also got that recorded classes, so you can accordingly cover it. And if there is any requirement for the material or anything, you can come back to us, we will be able to help you. So with this session, we will be able to wind up and complete what was there in RTP and MTP of November 20 for your inter syllabus.
Good, Kana.
Thank you, sir.
Excellent, excellent. Thank you. Thank you, students. Monday, what is the program, Kana? Yours program or Shanmunan's?
Monday we will take ITSM. ITSM and AASM.
Okay. Monday we are having how to approach ITSM and AASM program at 5 o'clock. Kindly share this info to your friends also. Study well. Bye bye, Kana. Thank you. Thank you, Bharath.
Thank you, sir. Thank you, sir.